If you are a Canadian who has been sued or are worried that one of your creditors is going to sue you, then you will want to watch this video. A creditor will sue you because if it obtains a judgment against you, it will gain access to extraordinary remedies in its attempts to recover monies from you. This includes placing a lien on real property, garnishing your wages or bank accounts, and in some cases, seizing some of your property. In this video, you are going to learn a number of tips and strategies for individuals who have been sued. Hi, I'm Mark Silverthorn. I hope you enjoyed this video. The information I am sharing with you is based upon my 3 decades of experience in the debt collection and debt relief industries, including 12 years working as a collection agency lawyer. The goal of the Debt Coach Silverthorn YouTube channel is to empower Canadians struggling with debt. If you have been sued, then there are a number of preliminary issues for you to consider. The first issue is whether or not there is any reason why you should file a defense. I will address this issue in more detail later in this video. The second issue is whether you are going to represent yourself, or are you going to hire a lawyer, or in those provinces where they exist, a licensed paralegal to represent you and presumably to file a defense on your behalf. You may be saying that I can't afford a lawyer or a paralegal to defend me. You might, however, want to consider hiring a civil litigation lawyer for a 1-hour consultation. This might cost you anywhere between $200 to $400, but it should provide you with an excellent analysis of your situation. If you are sued, then it can be helpful to have a basic understanding of what takes place in a civil lawsuit. There is a link in the description to this video to an article on my firm's website, debtcoachsilverthorn.ca, where I have summarized an overview of civil lawsuits. A creditor who sues someone is referred to as a plaintiff. The plaintiff will prepare a written claim and have it issued at the court. Many provinces have 2 separate courts for civil lawsuits. A small claims court with a ceiling on the dollar amount of claims, and a second court where higher dollar claims must be brought. The name of the document commencing a lawsuit against you will vary not only by province, but also by the court where the lawsuit is commenced. Once a creditor has its claim issued, it must then serve its claim on you, the debtor. If you have been sued, then the court refers to you as the defendant. Every court has specific rules as to what constitutes valid service of a claim. If you have been sued and you wish to defend the claim, then it will be necessary for you or your legal representative to defend the claim in a timely manner. The generic name for this document is a defense. The exact name of this document, however, varies not only by province as well as by the court where the lawsuit is commenced. Each court has rules setting out how much time you have to file your defense with the court. As a general rule, this period is in the 3 to 4 weeks range. Furthermore, it is not sufficient that you file your defense with the court. You must also serve a copy of your defense on your creditor before you can file your defense with the court. There are three scenarios where your creditor can obtain a judgment against you. Firstly, if you fail to file a timely defense with the court, then your creditor can obtain a default judgment against you. Secondly, sometimes prior to a trial, your creditor may go to court to obtain a judgment. This typically occurs where your creditor can persuade a judge that your defense is without any merits. Finally, a judge might grant a judgment to your creditor following a trial where it has proven its case on the balance of probabilities. If you have found this video helpful, then I would ask that you hit the like button. Your support means that more people will see this video. There are a number of reasons why you would want to file a defense. If you have a good defense to your creditor's claim, then you should file a defense. If, for example, a limitation period has expired, then filing a timely defense pleading the expiry of your province's statute of limitations as a full and complete defense should result in you winning your lawsuit. There is a link in the description to a video explaining how a Canadian can avoid paying a debt due to the passage of time. You might also want to file a defense if your creditor has provided you with defective goods. In some circumstances, you might want to file a defense in order to buy some time. If, for example, your house has been listed for sale, then ideally you would want a closing date to occur before your creditor can obtain a judgment and place a lien on your property. You might wish to negotiate a one-time lump sum settlement with your creditor, but need additional time to gather the necessary monies to fund your settlement. There is a link in the description to some videos on how to save money negotiating a one-time lump sum settlement with your creditors. You might also wish to file a defense so that you can meet with a licensed insolvency trustee and determine whether or not it is in your best interest to make a consumer proposal or file for personal bankruptcy. There are a number of reasons why you might not want to file a defense to a lawsuit. You might be judgment proof, in which case your creditor will not be in a position to recover monies from you if it were to obtain a judgment against you. There is a link in the description to a video explaining those scenarios where a Canadian is judgment proof and an individual's income and assets are beyond the reach of their creditors. You might be able to contact your creditor or your creditor's legal representative and finalize a one-time lump sum payment as settlement in full before the deadline for you filing a defense. When I was practicing law and representing consumers, one of my clients was sued by a major bank. I called the lawyer representing the bank and asked him for an undertaking not to seek a default judgment without first giving me 2 weeks' notice. I then asked him what the bank would accept as a one-time lump sum settlement. At the end of the day, my client did not have to file a defense. The bank accepted a one-time lump sum payment of $9,000 as settlement in full, and my client avoided a judgment and having a lien for $10,000 plus post-judgment interest being placed on his home. You might have made a consumer proposal or filed for personal bankruptcy through a licensed insolvency trustee that terminates the lawsuit against you. The technical name for this is a stay of proceedings. Creditors have a terrible reputation for recovering monies from individuals who have moved to another country. I know this all too well from managing legal departments at some of Canada's largest collection agencies. If you have incurred significant debts in Canada and you have a substantial net worth, then you might want to consider moving to another country. As a practical matter, your creditors might not be able to recover any monies from you after you move outside Canada. If you have found this video of value, then I would ask you to hit the subscribe button and the notification button. Your support means that more people will see this video. Watch more of our videos to learn how to deal with your debt situation.